Appleton and Oshkosh and Green Bay. With today's webinar, you will be sent out a couple of things. We also do have a question and answer feature that I just kind of want to show. If you have any questions as we talk about our topic today, which is all about probate and estate settlement, you can put those questions directly in the question and answer feature or in chat, and I will be able to answer those as we go. You by no means have to save your questions until the end. You can ask away on anything that kind of interests you within this topic, or if you start to have questions that might be a little bit easier to answer with more specific information, or things that you maybe don't feel comfortable asking in this kind of general format, you always have the ability to sign up for an initial consultation. So just know that with our office, we do offer 2-hour complimentary initial consultations where you can meet with an attorney from our office at one of our locations, and they'd be able to answer your questions and get you some things a little bit there too. But as I said, today's topic is all about probate and estate settlement. So there will be some materials that are sent out to you. We're going to have like a probate, non-probate assets handout, and we actually have a book all about probate and trust settlement. So that'll be sent out to anyone who had registered. You can actually sign up right in that email that you'll receive with some of those materials and things at the end if you had wanted us to reach out for that initial consultation and to provide any feedback for today's webinar. So I always love to know what you thought, if you have any remaining questions, or if there's any specific topics that you might want us to cover in the future. You can always put that in that feedback form as well. So, okay, I kind of want to get started today when we talk about probate versus estate settlement, or really like, trust settlement, really. Talking about, well, really what is probate? And probate is a court process that someone's estate would go through if they either, pass away without an estate plan, or if they have a will, which is one of the big things, is that sometimes people get confused that, well, I have a will, so I shouldn't actually need to go through probate. But your will, kind of in its simplest definition, is a set of directions to the probate court. So your will isn't going to have any sort of standing anywhere except in the probate process. So your will says good things like, this is my personal representative, or you might know that term as like an executor. I want this person to go ahead and pay my bills and lost expenses and settle my taxes. And then I want them to, give this amount of money here, and I want them to do this with the personal property, and then everything that's left, I want it to do this. So all of that planning that's in your will, if you want to use your will, then that actually means that you want to use the probate process. So, what is probate? It's really just the court process that's used to take anything that was in your name when you were alive and get it out to the people that you had in your will, or who might be considered your heirs at law if you didn't have a will. So probate helps to make sure that all your creditors and bills and things are settled as well. But oftentimes with probate, I think the reason that people will complain about probate, or maybe want to avoid that whole court process, comes down to about really 3 reasons. Number 1 has to do with the fact that, it's a court process, which actually sometimes people don't want to be in court or go through court. Probate can take on average about a year to a year and a half to complete. So it's not really a quick process. That's kind of what you hear for averages. Obviously, if there is a contested probate, that can take a lot longer than that kind of year to a year and a half average. Probate does typically cost anywhere, we hear averages, anywhere from like 3 to 5% on the value of whatever goes through probate. Now, that's not to say that that's a set fee for everyone. It really just depends on like how complicated the probate is, how many heirs there might be, the number of accounts that make up the estate can be a complicating factor. And then obviously if there's any litigation, it can be more expensive. One of the reasons why you see that percentage is because there are county fees associated with a probate, like inventory filing fees and other fees. Your personal representative typically takes like a 2% fee on average. And then if you involve an attorney, it can start to be a little bit towards some of those higher percentages. So You don't have to involve an attorney. It's just sometimes probate can be expensive for those reasons. It is also all public. So depending on how you feel about privacy, and I'll talk a little bit more about, who's entitled to what information and who's able to know what, just understand that probate, like most court processes, is public. So someone can request certain copies of information, be entitled to certain information related to the probate process. So when someone passes away, what's really going to happen with that probate is that will is going to be filed, or if there's not a will, then that person has passed. It's called intestate, which is kind of like they don't have a will, but the state of Wisconsin wrote them a will. So like if someone passes away without any estate plan in place, there are ways to identify who their heirs are going to be. It's kind of just like you might think about someone's family tree. Like if you're married and with no kids, everything to your spouse. If you're, widowed and you have kids and everything to those kids. And if you have no spouse and no kids, then they'll kind of see, well, do you have parents? Do you have siblings, nieces and nephews? And it kind of goes on from there. So even though your will might say that you're leaving assets to someone other than who are considered your heirs at law, there still has to be a lot of notice and information that still goes out to the heirs at law. So typically what happens with a will then, or the intestate proceeding, is that someone makes a filing with the register of probate, and then they have to go and serve the heirs and all of the interested persons. So whoever's receiving something from the will is obviously going to know that there's an action ongoing. And then whoever would have received, either if that will is revoked or kind of considered that heir at law. So sometimes people will disinherit someone like a child, or have different planning beyond who the law would consider to be their family. But just understand it's not only the people actually receiving something, it's also the people who would have received something. All of these people are kind of served notice. They have a chance to consent to that or to potentially object. Most people don't object. And then after that, the personal representative is approved. So once you actually have the will, that doesn't necessarily mean that that personal representative is going to be able to just like take the will down to the bank and start to pay bills and handle everything with the estate. They actually have to be approved, get that notice, and then they're issued what's called a domiciliary letter, which allows them to actually go ahead and start the probate process, pay all those bills, and get everything settled for the estate from there. So this kind of first set, in order to get those authorities, does typically take about a month to get the personal representative actually approved. Now, if it's a pretty small family and everyone actually consents, that can certainly be quicker. But there can be a little bit of an initial delay paying bills and all those things. But after that, that whole year to a year and a half does not mean that funds aren't going to be distributed or bills aren't going to be paid for a year. It just means that start to finish, that typically is how long probate will take. So with a trust administration or trust settlement, some differences that you might see between trust administration and probate really has to do with, now we're doing a lot of the same things that the will would have done, make sure bills are paid, that assets are going out according to that person's wishes. We're just not going through probate to do that. So that's one of the key distinctions really between like a probate or a trust settlement, is that in trust settlement, all of that is done privately. And what that can often mean is that we're doing really similar things to what we would have done in probate. We're just having that private. So typically trust administration, instead of that year to a year and a half that you'll see, takes more like 6 to 8 months start to finish. There can be an idea for someone about like a cost shift between whether a will is better or a trust is better. It has a lot to do with those kind of more average percentages that you see for fees. So like creating a trust is going to be more expensive for someone to create at the outset because it's more work and involves an attorney kind of ahead of time. But trust can be like a cost savings or a cost shift for the estate as a whole, depending on the size of the estate. So for example, trust administration, you tend to see in terms of those like administrative fees, more like 1% or a little under 1%. A professional trustee can be a little bit more in that 2% range. But if you have, say, for example, like $1 million estate, well, while your will would have been cheaper to create, if it costs you $30,000 to $50,000 to administer, it can ultimately be more expensive for your estate at the outset. So I have some clients that say that's the kid's problem, and that's completely fair. I just want you to make sure that you understand kind of sometimes how those fees might work for someone's estate, depending on what they have and what's going through probate and some of those other pieces. Trusts are more private inherently than wills would be, just because in wills, there has to be that notice and like a copy of the will that's given to the beneficiaries, the interested parties, and someone can go and request that. So if someone has the will, they're going to be able to see kind of the entire thing. Versus with trust, you can actually limit like, okay, only the people who are actually receiving something from me are entitled to any information. And you can further limit that and say only the information that pertains to them. So especially when it comes to probably more like disinheritance issues or a concern for privacy, trust administration tends to be better for those things than wills, just because of the public nature of probate. There are very valid reasons to actually want to go through probate and make sure that you have a probate process. One of the most important things that I see has to do with like deficit estates. So if a person actually owes more money than they have, that's kind of like their estate filing bankruptcy, they would want to have a probate administration rather than a trust administration, because then the court is going to decide, okay, this is how much money there was, these were all the creditors that they have, this is that order of priority, this is how much they get paid. And even if the family doesn't end up receiving anything from that person's estate, but at least they didn't receive the liabilities either. So if you have a deficit estate, you're going to want to be doing a probate more than you would a trust administration, just because of some of those factors. Another really important reason to actually use probate is, just to make sure that if you have that will-based plan and that's what you're hoping to do, that your will is actually then followed. If you have everything go by beneficiary designation and not be a part of the probate, then that will was a very nice piece of paper. It didn't end up doing really that much for you because nothing ended up going through probate. Sometimes I have clients who know that no matter what they do, their family is probably going to fight about their estate. So sometimes when you start in court, that can help you to have that judge be like an initial referee. So if you know that children are going to fight or family are going to fight, you may just want to start at probate to begin with. If you have minor children, you have to put guardian nominations in that will. So that's kind of the best place to actually make sure that then you put who you would want to take like guardianship or custody of the minor children in a will. And again, wills go through probate. And then kind of on the other side of that, why might someone want to use a trust? So there are different types of trusts. Often during someone's lifetime, we're typically talking about revocable trust because of their probate avoidance. Sometimes people have irrevocable trusts for specific purposes, like long-term care planning or estate tax planning or other specific goals. But when it comes to trust administration, whether it started off as that revocable or started off as that irrevocable, they tend to be pretty similar on the administration side. So oftentimes with trust, it really is about that probate avoidance. And often there's better like asset protection that you can create in trust when compared to wills. Because when you create certain asset protection for others, that's often better accomplished in a trust, A, because of that privacy, but B, because of possible like requirements that the court could have related to the monitoring or spending of that trust. So depending on someone's goals, it just determines as to whether or not probate is better or trust administration is better. But I wanted to make sure to walk through big picture, some of the operating differences between the two, but also identify their similarities. It really just comes down to whether someone's estate is wanting to use probate for some of those reasons, or maybe wanting to have a lot of that same planning, but just not have to take the year to a year and a half and those additional costs and things there. Any questions? I feel like I went through everything pretty quick, but that's just because I was comparing two things. If you have any questions, I'm always happy to answer. Otherwise, our probate and trust settlement book really breaks down a lot of these topics in more detail. We're also having, if you just have more questions on like, how do like wills work or trust work more during someone's lifetime? How are they created? Some of those pieces. We're actually having a wills versus trust public seminar, I believe, next week. So that's going to be more about wills and trust. It's at the Neville Public Museum. We do a 2 o'clock and a 6 o'clock. We're also going to be on the news tomorrow. If you have some questions on that too. We're back in April with another webinar all about like hunting land and family land. And then a little bit more on Medicaid on April 29th. So any of our events or questions that you have, you can see a full list of those on our website, or if you go to estateplanninglive.com, you can see those events and register more information and materials there. So otherwise, that was kind of everything for today. Thank you very much for your time. Have a good rest of your afternoon.